Open court.
Supreme Court of Kentucky, begin in session. You may be seated.
I see Harris. I recognize him with a beard.
The case to be heard at this hour is Mathis versus Martin. And I might observe that there are a number of distinguished judges of the Kentucky Court of Justice present today, and all of you are quite welcome to be here. For the appellant, Ms. Weddle, I believe you've requested 12 minutes with 3 for rebuttal. Is that correct? And for the appellee, Mr. Lyons, you'll have the normal 15 minutes. And counsel, I might ask a special favor of you. I'm going to allow an extra minute to each side and request that you give perhaps a development of the facts of the case a bit more fully than you might otherwise do for benefit of the audience here, so they'll have a factual basis for understanding what the case is about. Ms. Weddle, you may proceed.
Thank you, Mr. Lyons, Mr. Baggy. May it please the court. In this case, the respondent, Lillian Martin, is claiming an entitlement to a statutory 1/2 interest in a farm formerly owned by her late husband, Joe Martin.
Having great difficulty hearing
Speak
you.
up, please.
Sorry. In the Court of Appeals, in a departure from long-standing precedent of this court, held that the respondent is entitled to the statutory 1/2 interest in the farm, even though before Joe and Lillian Martin married, Joe had transferred title to the farm to a trust, an irrevocable trust for the benefit of his children. And Lillian Martin knew about that transfer before she and Joe married. The facts in this case, and I will go into a bit more detail as Your Honor requested, are not complicated. Joe and Lillian Martin were married in 1985. They were a mature couple. Both had been married before. Joe had 3 adult children from a first marriage that had ended with the death of his wife, the mother of his children. Joe had just emerged from a second marriage that ended in a very bitter divorce. Joe and Lillian had a short courtship, about less than 6 months. Joe had made the decision after his bitter divorce from his second wife that he wanted to take steps to preserve and protect the family farm where he had raised his children. It's called Highcroft Farm, so that he could pass that farm to his children at his death. He talked to his children about this desire. He talked to his attorney about this desire. And after Joe and Lillian discussed getting married, he also spoke with her about this desire. Various methods of accomplishing this were discussed. One method was to convey the farm to an irrevocable trust, where the trust would hold the farm, and then the trust would terminate at his death and the farm would pass to his children. Another possibility, and this was actually suggested by Lillian, was that the parties enter into a prenuptial agreement. Joe decided ultimately that he would like to do both of those things. He had his attorney draft an antenuptial agreement and draft papers to create an irrevocable trust and a deed to convey the farm. On the day before the wedding of Joe and Lillian, all of Joe's children and their spouses were in town for the wedding, and the children, their spouses, Joe and his attorney met, and Joe executed the trust documents, executed the deed document conveying the deed to the farm to the trust. That evening, the evening before the wedding, Joe told Lillian that he had signed the trust papers, had conveyed the farm to the trust. Also that evening, Joe learned from Lillian that she had taken the antenuptial agreement to her attorney and had decided, based on her attorney's advice, that she was not going to sign the antenuptial agreement. The antenuptial agreement provided that each party would retain title to the property they brought to the marriage, and each would relinquish any claims that they might have in property that the other had prior to the marriage.
Now, Lillian had been given a copy of the antenuptial agreement, but not of these trust documents?
That's correct, Your Honor. Before the marriage, she was told about the trust documents and the conveyance, but she had not seen the document.
What was she told?
She was told that a trust had been created, that the farm had been conveyed to the trust, that it was for the benefit of Joe's children, which she was aware of his desire to structure that based on the discussions and the antenuptial agreement that she had seen. Notwithstanding these developments the night before the wedding, Joe and Lillian proceeded to get married the next day. They were married for about 12 years, and not a sign, I take.
No, that's not a sign either.
It's not a sign.
Joe died intestate in 1997. Lillian was appointed the administratrix of his estate, and she shortly thereafter brought this action, asserting the claim to the property. Initially, in this case, Lillian also asserted a claim to other personality that Joe had conveyed to the trust. All of those issues have been settled by the parties. The farm is the only property still in issue.
They
in
have
the case.
settled the issue regarding the second group of
Conveyances.
conveyances.
That's correct, Your Honor.
Which primarily involve personal property.
That's right, Your Honor.
And an interest in a farm in Florida?
That's correct. Yes, that's right. Although I think that was sold during the marriage.
So the only issue before us then is the main farm that was transferred to the trust agreement the day before the marriage.
That's correct, Your Honor.
So you think that was sold during the marriage, the half interest in the farm in Florida?
I'm not entirely certain, Your Honor. I believe it might have been.
Lean forward, Jim.
Did, you don't know?
Are you talking about the property in Florida?
Yeah, half interest that was put into the trust, wasn't it?
I don't believe a deed was ever actually written to do that. There was a document listing it as an addendum to the things to be conveyed to the trust. I don't believe a deed was actually signed conveying it. The parties filed cross motions for summary judgment in the trial court. The trial court granted summary judgment in favor of Lillian Martin, finding that she did in fact have a statutory 1/2 interest in the farm. We appealed that to the Court of Appeals, and the Court of Appeals affirmed that ruling. For at least 150 years, Kentucky courts have recognized that a person engaged to be married does not have the same legal rights in the property of their intended spouse that they acquire upon marriage to that person. Stated conversely, Kentucky courts have recognized that an unmarried person, a person who is engaged to be married, is not under the same limitations to autonomously convey their property as they are under when they are married.
Is there some sort of middle ground in there, though, counsel? I mean, a single person can dispose of his or her property pretty much as they choose to. A married person obviously has some restrictions on the disposition of their property, with which we're very familiar, but is there some middle ground in there? And if so, when does that begin?
That's exactly right, Your Honor. And what the courts have held is that the person who is engaged to be married but not yet married does not actually have a vested right in the property of their intended, but they have the potential to acquire that right upon marriage. And they may be entering the marriage with certain expectations about the property that is held by their intended. And
Well,
if
you know, I understand the difference in your all's arguments, but it seems to me there must be some type of a vested right, because the line of cases that you cite seem to say that if the fiance is advised of a transfer and prior to marriage and after marriage decides differently, there's been no fraud. If there is no revelation of this transfer, then that's a fraud on dower. And I'm wondering apparently something vests prior to the marriage.
prior to the marriage, Your Honor, there is, as I said, there is an expectation of acquiring an interest in the property upon marriage. And if there is a change in the circumstances that would therefore change that expectation if the person knew about it, and that change is concealed or hidden from the person who is going forward with the marriage, perhaps upon the assumption or under the influence of that knowledge, then there is certainly, the cases have held that there is a fraudulent intent. That is, the person has entered into the marriage with the belief that certain properties are held by their intended, that they will acquire a vested right upon marriage, but if they are not informed of the change in circumstances prior to the time they married, then there has been a fraud on that expectation.
I have two questions I'd like to ask you. The first one is I want you to comment on this statement that's made in Roe versus Ratliff, which is a 1937 case, and says a conveyance of real estate made by one after an agreement to marry without consideration and without the knowledge or consent of his intended wife is a fraud on the wife. Considering that statement and the case in which the court abolished, I guess is the correct word, the tort of breach of promise to marry, does that have any effect, do you think, on these older cases that are being cited as authority?
I think, first of all, Your Honor, the Roe case itself involved a conveyance that was made after marriage. So to the extent that the court was commenting on the rule as it affects premarital property interests of an intended spouse, it can be considered dicta. But
Well, in Roe, it wasn't the transfer. Well, I guess maybe wasn't the transfer that was after. It was the knowledge that came after the marriage. Is that what you're saying?
no, it was both, Your Honor. It was the transfer and
Transfer
the
and the
knowledge.
knowledge.
And
That's
you have
correct.
to have consent after a marriage.
Exactly.
So you point out that that's just dictum that we don't have to follow.
I think that's correct, Your Honor. That the holding in that case applied to a transfer made after marriage when the right had clearly vested.
Of course, they cited 3 or 4 cases for that statement that even go back into the 1800s, which is maybe good or bad.
Well, and also, Your Honor, as far as the language that you just quoted, that there should be knowledge or consent, I think the older cases that we rely on and that I think really have not been changed by the later cases indicate that going forward with the marriage signifies the consent. Knowledge plus going forward with the marriage is the consent that is needed if consent is deemed to be needed for a premarital transfer.
I'm having trouble hearing you.
I'm sorry. The language that you quoted was knowledge or consent of the intended spouse. In the earlier cases, knowledge plus going forward with the marriage was considered to be consent to the transfer.
Kind of like a waiver.
Essentially, that's right, Your Honor.
Do you think that the case that abolished the tort of breach of promise to marry has any effect on this case at all?
I don't think it affects the outcome of the case, Your Honor. I think it changes certainly some of the underlying thoughts that might have been applied at the time the earlier cases were decided. For example, it was noted that the knowledge of a premarital transfer and then a decision to not go through with the marriage, if that person were then sued for breach of promise to marry, the transfer might be a defense to that. But I don't think it affects the rulings that we advocate in this case. I don't.
Don't think it changes any expectations.
I don't think so. Not in the sense of what the property holdings are. The rule that the Court of Appeals has adopted essentially obliterates the distinction between a premarital interest in property, in the intended's property, and the post-marriage interest in a spouse's property. Essentially, the Court of Appeals creates a vested statutory right in an unmarried person in the property of another unmarried person.
Counsel, what's the triggering event from the Court of Appeals perspective of that? Is it the agreement to marry?
Well, that appears to be the case, Your Honor, once there is an agreement to marry. And I think that's part of the troubling part of the rule that the Court of Appeals has crafted. The state of being engaged or having agreed to marry is clearly much less identifiable, less clearly defined than the state of being married. Often the parties themselves are not entirely certain as to what their relationship is, or they may think they're certain and not be in agreement with one another as to what that relationship is, unbeknownst to one another. And it's very difficult, I submit it will be very difficult to implement the rule that the Court of Appeals has crafted when you have that kind of uncertainty to bring to these conveyance transactions.
Is there any significance in the fact that the revelation of the conveyance to the trust was not made until the day before the marriage? After all, that would a lot of people put a considerable lot of time and interest and even expense into planning a wedding, and it's kind of hard to pull the plug on a wedding at the last minute. I mean, is there an element of coercion associated with that?
Certainly the cases that we rely on have addressed that point very specifically and said that there has to be a line at which point the right vests and at which point the person who is learning of the transfer can't turn back. And that point is right up to the marriage ceremony. And in the Cheshire versus Payne case, in fact, the groom-to-be learned of a transfer that his bride-to-be had made, and he learned of it only moments before the ceremony. And the court spoke about that fact, but said up until the point that the vows are exchanged and the marriage is a marriage, he has the chance to back out. Now, there might be, you're right, expenses gone to, plans have been made, plans have been changed, and perhaps there would be some sort of promissory estoppel claim that could be made.
Prenuptials are signed as a play, here comes the bride.
Exactly, exactly.
So much for true love.
Yeah.
People don't like to address these issues, and they tend to put them off.
Like in the Gentry case, that prenuptial was signed shortly before the marriage.
Counsel, you'll have 1 minute to wrap up.
Thank you, Your Honor. The Court of Appeals cited 4 cases in coming to their decision. 3 of those cases involve nothing but post-marriage transfers. Their holdings do not in any way affect, change, or support a modification of the existing rule. The 4th case involved a pre-marriage transfer without knowledge of the intended spouse. I know respondents have argued in their brief that perhaps there was knowledge in that case because it is not explicitly stated in the court's opinion, however, and I'm talking about the Martin versus Martin case. However, the facts make it very clear that there was an element of secrecy because the husband was transferring property to his sister, actually bank accounts to his sister, because he feared that his intended might choose to sue him, and he did not want her to have access or knowledge about where those accounts were. That case does not stand for or support any change or departure from or modification of the existing rule either. And again, we suggest that the Court of Appeals rule would be very difficult to enforce in any uniform
Did
way.
you ask for a jury trial on any of the factual issues in this case?
Your Honor, I did not handle it at the trial court, and I don't know the answer to that.
Thank you, counsel. You'll
Thank
have
you, Your
time
Honor.
for rebuttal.
Thank you.
Mr. Lyons.
Counsel. May it please the court.
Speak directly into the microphone, counsel.
In view of the court's instructions to talk a little bit about more about the facts, I want to add a few additional facts that were not addressed. First of all, the courtship that was involved between Lillian and Joe was a courtship of longer standing than implied by counsel. In fact, he had had a courtship or a relationship with her before he had what they referred to as the second marriage that ended in divorce. He reestablished that relationship after his second marriage fell apart. He contacted Lillian, reestablished that relationship.
Lillian didn't have any expectations while he was married to his second wife, I assume.
No, Your Honor, she did not. She was a little surprised that he contacted her because she was not aware that he was breaking up with the second wife. I think she was also surprised that he married someone else besides her, perhaps, but I don't think she had any expectations during the marriage. The court asked the question about what Joe told Lillian about the trust, and he told
I
her.
noticed in the transcript attached to someone's brief, it says, "But I wasn't marrying at the time for his money, anything. Just married. I was just." It stops.
That's what she did say that. But there were two things that Joe told her, and that's the only thing she knew about the trust. Number one, he said, my children made me feel guilty, so I signed a trust. And somewhere she got the implication that the farm was placed in that trust, or he told her. And the second thing was she said, well, that means your children control you can't sell your farm without your children consent. He said, I'll be the maddest man in the world if I can't sell my farm. That's all she was told about the trust. She wasn't given a copy. She wasn't given a copy of the deed. The only document that she had was the antenuptial agreement. If the court refers to that, it contains many blanks where his assets are to be that were not completed.
Well, they had, and correct me if I'm wrong, hadn't they discussed keeping some of the property that they owned prior to this marriage we're talking about separate and apart for their children?
Both of them.
I mean, which seems to be fairly common these days. It seems like people experience more than one marriage during a lifetime, and it seems to be a very routine thing to talk about assets a lot more than we used to, and keeping those separate in a second or third marriage. They had discussed that, hadn't they?
The primary discussion centered around having an antenuptial agreement. Lillian was not particularly sophisticated about these documents that she was talking about. A friend had told her the thing to do was have an antenuptial agreement, so she threw that language out there. That's what she testified in her deposition. And I don't think she anticipated, there are antenuptial agreements, there are antenuptial agreements. Some provide that the property is to be completely kept in the hands of the spouse that owned it. Others provide for a payment to the spouse, or even provide for some means of support to the spouse for the rest of her life. I do not believe that Lillian anticipated that an antenuptial agreement would prevent her from receiving support for the rest of her life after Joe died.
But she did have there was some discussion about her having knowledge that Joe, the husband, meant to keep this farm for his children, wasn't there?
There was discussion that she testified about concerning incorporating the farm. And that was apparently one of the alternatives that the attorney presented to Joe. And in fact, Joe told her, well, you can be, I forget, secretary or vice president, or one of the officers of the corporation. But obviously that doesn't necessarily, being told that, indicate to you that you're not going to get support, or that you're completely cut out from any kind of benefit from the estate for your support after he dies.
Well, and I'm looking on page 3 of the appellant's brief, where there's some quotations from the Buckley deposition that says Lillian was well aware of Joe's desire to preserve Highcroft Farm for the benefit of his children.
He did say that, but Lillian's testimony was to the contrary. And I don't think that fact is particularly pertinent, because up until the time that she was married to Joe, she had no idea that what Joe and his children were planning to do was to cut her out completely. Remember, there was some reference to a settlement of personal property issues. I want to clarify that for the court. The settlement occurred on a counterclaim by Joe's children that Lillian had taken some property that belonged to Joe. That was the settlement. When they came into court, they wanted to enforce not only the trust containing the real estate, they wanted to enforce this addendum that was signed the day of the marriage, that she was not told about until after the marriage, that rendered, by their own admission, rendered Joe a pauper. Now, this was the extent to which they were going to cut her out of Joe's estate, and she didn't know that.
Now, he was life beneficiary of the trust.
He was life beneficiary of the trust, that's
So
true.
how could he be a pauper of a $1 million trust?
Well, the estate itself owned nothing. So he owned nothing when he died. Everything was in the trust. So when his life estate ended,
The state may have ended up a pauper, but during
Well,
his lifetime, he had the income,
Yeah,
enjoyed the
that's
income
true.
from
He
$1
had
million.
the income. He had the
Yeah, big
income. But it
trust.
rendered him a pauper at his death.
Yeah.
And they admitted that. It rendered him a pauper at his death. His daughter.
She didn't sign this antenuptial agreement, did she?
She did not upon advice of counsel.
Right, on the advice of counsel.
That's correct.
So counsel was involved in this. I think you or someone said that she didn't see the document.
what happened, she did not see the trust, nor the addendum to the trust, nor the deed to the trust until after the marriage. The antenuptial agreement was given to her the Tuesday before the marriage on Saturday. She tried to get an attorney, to see an attorney. She was able to get an attorney at Stalkin and Park, a prominent law firm in Kentucky, and went to see that attorney on the Friday before the wedding, which is the first time she could go see him. And she took the document that's in the record that contains all the blanks in it, that's in that document, no disclosures of anything. And he advised her not to sign that document, and she did not upon the advice of counsel. And that's the circumstances under which she received the antenuptial agreement.
What about the half interest in the Florida property?
That property was disposed of during the marriage, and Joe used the proceeds. The addendum that was signed on the day of the marriage purported to place that in the trust.
But there was no deed?
To my knowledge, there was no deed. No deed has been discovered, but that's what they attempted to do. Joe disregarded that and just sold it when he felt the need to sell it and used the proceeds.
At what point did Mrs. Martin learn what was in the trust document?
After the marriage, at some point in time, probably within a couple of weeks or so after the marriage, she was given a copy of the trust. Might have been a month, but it was within a month. She was given a copy of the trust, and I think perhaps the deed. The deed was not recorded until a week later after the marriage. And she took that to counsel because she felt some concern from the children because she had not signed the antenuptial. She wanted to pursue signing a postnuptial agreement. So she went to counsel and she took these as pertinent documents, and that's when she found out the impact on her was after the marriage.
Well, would it have made any difference in your case if she had been provided all of these documents 6 months before, took them all to a lawyer, and he said, well, if I were you, here's what's going to happen, and I would advise you not to, and she'd gone ahead with the marriage, would your case be any different right now?
I think it would, Your Honor.
So the knowledge, you're conceding that knowledge prior to the marriage is a very important factor that we have to look at.
I think it's a factor, but let me put it to you a different way, Your Honor. I think the issue in this case is, given the fact that the fraudulent intent is admitted, that is, there is fraud on dower, is there something in this case that will excuse that and relieve the appellants of the consequences of that fraud on dower? And they're saying mere knowledge will do that. What I'm saying, based on the cases that follow Martin versus Martin, Harris versus Rock and Anderson, is that knowledge in and of itself is not adequate. What we're talking about is consent or agreement. Now, knowledge can be an element of consent because there are two ways to consent to this. One way to consent to this would be express consent. If she'd signed the antenuptial agreement, assuming it had been a valid agreement, which it is not on its face, but assuming she signed a valid antenuptial agreement with knowledge of what she was doing, that would be express consent. That was not done. There is no express consent. The question is, can you imply consent from what took place?
Why couldn't you imply that consent from the fact that she went forward with the marriage after having learned the true state of affairs?
She did not learn the true state of affairs, Your Honor. She did not have all the facts before her. She did not. There are two analogies or two issues that I want to address in addressing that question. Number one, there's an analogy to the antenuptial agreement. When parties are in this relationship, this is not a property issue. This is a duty issue. It's a confidential relationship, and the parties have a duty to full disclosure to one another. That's the basis for our law on antenuptial agreements, why there has to be disclosure, not only of the extent of the estate, but also disclosure under the Potter case of how that affects the marital rights of the party.
Because they're entering into a contract.
But that's another form of consent. That's express consent. But I think implied consent involves the same kind of a knowledge issue. How can you say that someone who expressly signs an antenuptial agreement and can set aside that agreement because the disclosures weren't made, how can that person be given greater protection than someone who has this thrust upon them?
I'm just having a struggle here with this. I don't think of marriage as a business transaction, I guess, and yet this whole argument seems to indicate, well, these people got married because they wanted their spouse's property. Now, my concept of dower has always been that it's something that a spouse acquires as a result of the marriage, and it occurs at the time the marriage occurs. And this whole argument has been that this lady acquired an interest in her husband's property sometime before she got married, and that by transferring it to a trust in favor of his children before they got married, he somehow took away from her something that she had a vested interest in. And I'm having, particularly since we've done away with the tort of breach of promise to marriage, and if you read that opinion, there's a lot of talk in there about what a marriage is as opposed to what a business transaction is. And can you expound on that for me? Why am I missing the point here?
Happy to, Your Honor. I think the problem is that we're looking at this, as you say, as a business transaction or a property right, and that's not where this issue arises. The issue arises out of the duties between two people, because this is a relationship. Even going into a marriage like this, there's a relationship with certain expectations involved, and the court has said in the Simpson case that I cited in my brief that this is a confidential relationship and it involves a duty of full disclosure. That is also
I understand if we have a prenuptial agreement, we have a contract here, but we don't have any contract that pertains to just getting married anymore. And it seems to me like that she doesn't have any expectation to inherit his property until the marriage takes place and that property is established at the time of the marriage. I just can't believe that we're at the point where somebody, as soon as they get an engagement ring, gets a vested right in their proposed spouse's property that they can sue on 10 years later after he's dead.
Well, I don't think that's exactly the way I'm trying to state it, Your Honor. What happens is there's a relationship with certain expectations involved, and certain mutual duties are involved. Now, there are ways, if the person wants to do away with those expectations and potential relationships by an antenuptial agreement or by full disclosure and doing what he wants to do. But there's a duty in there.
An antenuptial agreement has to do with that she won't acquire dower rights when the marriage takes place. That's not what we're dealing with here.
I'm sorry, I didn't hear the full question.
An antenuptial agreement is an agreement that a spouse will not acquire dower or courtesy rights as a result of the marriage. That's not what we're dealing with here.
Well, an antenuptial agreement can be many things. It can be that, but it can be other things as well. It can establish a level of support. It can theoretically, you don't see many of them, but it can theoretically grant a spouse greater rights than she would receive as a result of the statutory share rights. So an antenuptial agreement, to say there's an antenuptial agreement, to me means a whole spectrum of things that it could possibly be.
We don't have. That's one reason I asked the earlier question. The antenuptial aspect of this case, with respect to the personal property, and she never signed the antenuptial agreement, so we're not dealing with the enforcement of an antenuptial agreement. And this case is not about an antenuptial agreement. This case is about a man who transferred his farm into a trust in favor of his children before he got married.
For the express purpose of cutting out his wife. That was his express purpose to his lawyer, express purpose to his spouses.
She wasn't his wife at the time.
But Martin versus Martin has no such distinction.
Well,
that applies pre-marriage as well as
I have a
post-marriage.
problem. If that case is the law, I have a problem with it.
Well,
That's what I'm having problems with, is the way you define fraud in this situation, because we know fraud, as we customarily use it, is there's a representation that's made and you intend someone to rely upon that representation. They rely upon it and that representation is false and they're damaged by it. You're defining fraud, and I see support for what you're saying is if you intend to defeat dower or courtesy, then you've committed fraud. And we know that there's all kinds of agreements and contracts that are entered into just for that purpose, and it's not fraudulent to do that. I mean, they have knowledge and consent to it. And
if there's knowledge and consent, then that alleviates the fraud, but there was not the knowledge and consent in this case.
But it has to be done with, so if she knew that this property had been conveyed into a trust and it was no longer his property, how could he defraud her?
Well, let me talk about two things, because there's an assumption here that she knew what was going on with this trust.
Was that a factual question?
Well, they're saying that mere knowledge is enough, and there's only one person still living that knows what was said, and that's Lillian. Her testimony.
But you have the evidence in there, and wouldn't that be a factual question for either the judge or the jury to determine from the evidence rather than a summary judgment.
If there's a conflict of fact, but in this case, the facts are not conflicted. There's just, the facts are there. There's no conflict of facts.
But there's different
No
emphasis
issue.
being drawn from this, because in her deposition, you at least understood that if the farm was in the trust, he didn't have free control over the farm anymore. Well, I'd rather surmise that. Could a judge, based upon that, or a jury make a determination that she knew prior to the marriage that he had conveyed that property to his children, and that she was not going to take any interest in that, and she consented to it by going ahead with the marriage?
I don't think that can be surmised from all the facts, because the second thing he told her was to essentially take that back and say, I'll be the maddest man in the world if I can't do that. And so what was she left with? She was left with what her surmise was and told it was wrong. So in effect, the facts don't support that position, because she wasn't disclosed exactly how, or even remotely how, that impacted on her marital rights. As I don't want to get bogged down in antenuptial agreements, but I'm using antenuptial agreements as a parallel to what we're talking about here. I do want to talk about a couple of the cases that they rely on in this same vein, and that's the Smith versus Irwin and Murray versus Murray case, because I think that sheds light on this particular issue, and it also discusses the same kind of disclosures that are needed for antenuptial agreements. In the Smith case, she refused to marry the husband when she found out about this transaction. Then they worked on her for a while, and a few weeks later she married him. And the Smith case says she married with full knowledge of all the facts, and that's what they relied on. That's where they implied the consent. The second case is Murray. And in that case, her real claim was that he said he was going to transfer this land to his children, but he actually kept a life interest, and that was a causa mortis gift, and therefore it was in fraud of her dower rights. And the court said, there's really no real distinction there in the amount that was given. In fact, it was a benefit to her, but it also said, in talking about the knowledge and consent, that she had supposed it would be an absolute conveyance, and that was not considered important, and that she supposed it was not unreasonable in view of his financial condition as stated to her by him. I think that gives us some guidance as well, that the same kinds of disclosures we're talking about for antenuptial agreements should also be the standard for the kinds of disclosures we're talking about for these kinds of situations. Can I come in and tell a prospective spouse, by the way, I've put part of my property in trust. I'm not going to tell you that I'm going to try to put the rest of it in trust tomorrow.
Well, the rest of it's not an issue in this case.
Well, it shows their intent.
Yeah, but the rest
shows
of it's
the
not an
fraud.
issue. That's out of
They've
this
abandoned
case.
that.
Well, and the rest of it all ended up from this addendum, I believe, didn't it? Isn't that where the personality came from? Some addendum that actually either one of Joe's kids or one of the in-laws actually drafted. I don't think they went to a lawyer for the addendum, did they?
They did not.
No.
And this addendum resulted from, on the eve of the wedding, Lillian saying, I'm not signing that, or them disclosing that I'm not going to sign that antenuptial agreement. And so all of a sudden, hey, let's get an addendum and take all the personal property too. And we have these depositions where these leading questions are asked. Well, in other words, you meant to leave him a pauper. I don't know that they volunteered that their intent was to leave Lillian or Joseph a pauper. But, it looks like to me, if we're talking about what did Lillian know, and I think you're saying that's part of it, and we are talking about this antenuptial agreement that she did have, that she did take to this prestigious Lexington law firm, in which there are provisions that this property, after they acknowledge certain pieces of property, one of them is this farm, that would remain the separate property, and the income would remain the separate property of Joe's, and that after the marriage, and that at no time would she ever make a claim on the farm. She knew that he was thinking of that when the antenuptial was drafted, didn't she?
She knew the Tuesday before the Saturday wedding that's what he had placed in the antenuptial agreement.
Counsel,
Well, actually, she knew that, I should say, on the Friday when she talked to her attorney.
Counsel, the trial judge drafted a couple of sentences in which he said various parties, defendant testified in deposition that the purpose of this transfer of property was so he could pass all of his property to his children upon his death. It is also clear Lillian Martin knew of his actions, did not acquiesce in or approve his actions, but married Joe the next day. Isn't that a fair statement of what happened?
Well, I think it's a fair summary, but I don't think it addresses the issue that's presented to this court, which is What did she know, and is that sufficient to justify consent to this transaction? And all she knew were those two things that he told her. There's a whole list of things that she didn't know.
Counsel,
She didn't know the value of the property. Excuse
1
me.
minute to wrap up.
Okay. There are a whole list of things that she did not know that I think are pertinent to this situation. Didn't know the value of the property going into the trust, the value of her marital rights that were being defeated. She didn't know the effect of the trust on her. She didn't have a copy of the trust document itself. She didn't know about this addendum that was coming up the next day. All these things that were going on, she didn't know. She knew there was an antenuptial agreement which contained blanks, which had no full disclosures, which I don't believe this court would have enforced under those circumstances without any disclosures. She knew about that.
Problem with that analysis, if she knew or didn't know, she married him anyway. Where does that leave her? Is this a trap?
Well, I'm not sure I follow the question.
Is it a trap to get a lawsuit in effect?
Well, I don't think so. I don't think that was going through her mind. She really didn't understand until after she was married what in effect had been done.
But she did have counsel other than yourself.
She had counsel that reviewed the antenuptial agreement, then she had counsel that told her about
Is that a
the trust afterwards.
limited representation?
The antenuptial agreement discussion was a limited representation, just to advise her on that. Afterwards, she was looking into the idea of a postnuptial agreement to satisfy the children.
She did that all
That's
on her own?
Well, she got Joe to go to one attorney who declined the representation after the wedding, and then after the marriage, and then she went to another attorney. He didn't go the second time.
Did she marry him for his money?
I don't think so, Your Honor. But I think she expected that she would receive the support that a wife or a spouse would receive under the Kentucky law, and that he would not attempt to take all of his property out of his estate in order to deny her.
Why did he give her a prenuptial agreement to sign if she believed that?
I'm sorry, I didn't hear that.
Well, you're saying that she expected to get all of his property, but she didn't marry him for his money, but she certainly knew that he wanted her to sign a prenuptial agreement which would give his money to his children after his death.
Yeah, and she had refused to do that. That's not what she had
refused to do
anticipated.
it. That's correct.
That's what she had anticipated.
Thank you, counsel.
Thank you, Your Honor.
Ms. Whittle?
Your Honor, I think the court has addressed most of the.
Speak up, counsel.
I believe the court has addressed the issues that I would have raised with respect to Mr. Lyons' presentation, but I'm happy to answer any questions that the court might have.
Thank you, counsel.
Thank you.
Recess court until 10 after the hour.